And here we go, opening with chaos. Notice how the defendant immediately challenges authority instead of listening. In court, this never ends well. Judges value order, not sass.
What's your likeness for?
First of all, I don't know who you think you're talking to, but do you want to spend an extra 30 days in custody? No, you don't. You don't care. That's why you're here charged with something.
What is your likeness for?
I don't have to answer you, and I don't answer to you. And I'm not going to start now. Case number 25S00791. FY, People State of Michigan versus Timothy Dance.
Secretary on behalf of people.
Illinois, P87446, Stephen in for the attorney of record, Don Donald, and Gary on behalf of Mr. Dansby, who stands to my right. Mr. Dansby, can you please state your name for the record?
My name is Timothy Dansby, and I'm often represent myself and I'll take counsel as an assistant, you know. So I don't know who this being here. I never signed for no representation of counsel, so.
Okay, you don't want a lawyer?
This is where it gets interesting. The defendant insists on representing himself, a move known as pro se. It sounds bold, but in reality, it's almost always a disaster. Think of it like performing your own surgery with a butter knife.
You don't have to have one.
I'm gonna need somebody because apparently I can't get a hold of no paperwork I haven't received my discovery back.
Well, that's what we got lawyers for, sir.
To the cash machine to get to the lawyer very well. I was in the county, so it's paying me hard. So I'm gonna need some type of system.
Okay, well, that's what we got for you. Okay.
I'm gonna represent myself.
Well, we don't have standby lawyers. So either you want a lawyer or you do not.
Well, first is I want to go ahead on with the preliminary.
Okay, well, first of all, you're charged with.
Boom. That's the hammer. First-degree retail fraud is no joke. It's a felony. Up to 5 years behind bars. At this moment, you'd expect the defendant to be dead serious. Instead, he's still sparring with the judge. Not smart.
Retail fraud, first degree. Now, first degree retail fraud is a felony charge. So the maximum penalty on this charge, let's see.
I believe it's 5 years.
Yeah, 5 years and a $10,000 fine or 3 times the value. You know what? Let me tell you something. You got a happy mouth.
I got a brain go with you.
You can have but you're disrespecting me.
I'm sorry.
Now I'm talking and you just cutting me off. So if nobody said you don't have a brain or anything, you just need to stop talking and listen to what I'm saying. All right. So this charge, you have a right to have a preliminary examination on this charge within 21 days of your arraignment date and within 7 days of today's probable cause date. So preliminary examination.
This is Court 101. A preliminary exam is basically the test drive before trial. The prosecution doesn't have to prove guilt beyond a reasonable doubt here, just that there's enough evidence to move forward. Think of it as the legal version of should this case even be on the road.
Is the probable cause hearing, where the prosecution puts on evidence to show probable cause to believe that this crime of retail fraud first degree was committed and that you were likely the one who committed it. And if in fact we have that hearing and they meet that burden, I'm going to send this over to circuit court for trial. If they don't meet their burden of proof, then of course this could be dismissed at this level. All right. So you understand all that? Now you don't have the discovery because I'm sure your lawyer probably doesn't have it either. Does Mr. Gonick have discovery?
Yesterday, we received paper discovery late yesterday. It will be sent to Mr. Danby today, and have not received any audiovisual discovery from my understanding.
I like to down if you don't mind. Probably motion, you know what I'm saying, for the fact that I haven't been denied. You know what I'm saying? And it's happening about it. You know what I'm saying? And the prosecutor was conduct, we should be about government training. Even though
Okay, that's a lot of talking. Where's the prosecutor? Yeah, but where's the prosecutorial misconduct?
Well, I should have had my discovery, dog.
Sir.
Yeah.
Do you understand how this process works?
No.
Well, no, you shouldn't have had your discovery. Because this is the first hearing.
So in the first year, I don't prepare anything if I don't have any paper.
First of all, there is no preparing of anything just yet. Just yet. Because
I'm supposed to just stand here and just like, oh, yes, come on, this is not slavery. This is not it.
Whoa, did you catch that? The defendant just swerved into sovereign citizen territory, claiming the court has no authority over him. Judges hear this argument a lot, and spoiler alert, it never works. Ever.
I'm not the one, you know. I am not the one. I don't care nothing about the United States. First of all,
apparently not.
court.
You must not care too much about anything, sir. Okay.
Don't even have a license. What's your license for?
First of all, I don't know who you think you're talking to. But do you want to spend an extra 30 days in custody? No, you don't. You don't care. That's why you're here charged with something.
What is your license for?
I don't have to answer you, and I don't answer to you. And I'm not going to start now. You need to settle down. You don't need to.
And just like that, order is restored. Judges have zero patience for courtroom meltdowns. When you talk over the bench, you don't win the argument, you win a trip out the door.
Settle down. Okay, take him out of here, please. That's okay. He's having his moments. So we're gonna adjourn this, and I'm gonna waive the 21-day, 7-day rule for this discovery. Yeah, welcome to Friday. All right, so we'll give you what do you think? You could just need video?
Understanding, yes.
Okay. So we'll give like a couple weeks to do it.
Yes.
And he's gonna want to see it, so you're probably gonna need to have him take a laptop over there to the jail and take his license to practice law to him. Okay. All right. So the next probable cause conference on this charge is gonna be.
All right, I just, to make a record as regards to that discovery, I do have paper discovery, which counsel has noted that has been tendered already. I do not have, does not appear that I have audiovisual discovery in my possession, but I will seek it should it exist.
Okay. If it does, it does. You know, if it doesn't, there's not much we can do. But we'll see if it does, and we'll come back on.
Court's available August 25th at 9:30.
August 25th at 9:30. And hopefully your client will have had a chance to review everything and we'll be a little more settled down.
Mr. Dominic will be in trial in the Wayne County Circuit Court. I can make that they work for myself if you're wanting Mr. Dominic to be here.
Well, we're not holding an exam on that date, so you'll be able to tell us if you want one or waive it. If you think you can handle him, I'm happy to have you come back. If you think Mr. Gonick should handle him, then we'll give you a new date. It's up to you.
I would say in this instance, I would feel more comfortable with Mr. Gonick. Handled his own.
Well, you know what? You got to cut your teeth somehow.
This moment's actually funny. The judge is cracking a joke about difficult clients. Even in serious hearings, judges sometimes use humor to lighten the mood. But make no mistake, underneath the laughter, the case is still deadly serious.
We've all had this.
Just don't
ask Miss Gracie. Okay. Ask Mr. Puda. We've all dealt with difficult clients.
We got this Gracie right. He's an expert in us.
I've had my share over the years when I was licensed to practice law. So by his standards, I'm not licensed. Okay. Yeah. 25th at 9:30 will be good. His bond will be continued. And just have Mr. Gonick visit him and talk to him, and hopefully he'll be a little more settled down. Okay, that concludes that matter.